Hello, my name is David Fye, Executive Director for the Kansas Behavioral Sciences Regulatory Board. I ask the members of the Professional Counseling Advisory Committee's Subcommittee on Unprofessional Conduct Regulations Review to respond to a roll call to signify their presence at this open meeting that is being conducted remotely by conference call and other electronic medium. So when I say your name, just go ahead and indicate if you are present. Jessica Allison.
Present.
Michelle Fairbank.
Present.
Bob Kircher.
Present.
Andrew Secor.
Present.
And I note the following BSRB staff are also present: David Fye and Leslie Allen. And
Present.
next, I'll read a message concerning this meeting being held remotely. Public comment allows the public to address the subcommittee about its concerns, but the Kansas Open Meeting Act, or KOMA, does not require the subcommittee to provide public comment or answer questions from individuals. Individuals requesting to provide public comment could contact the executive director prior to the meeting by sending an email to david.fye@ks.gov. There will be no public comment at this meeting as no individuals requested to provide public comment. Because we are conducting this public meeting remotely by conference call and other teleconference ability, I state for the record the following information. Public access to this meeting is being conducted by a medium of interactive communication that allows members of the public without cost to attend the meeting through the use of the conference call and on the board's YouTube channel. While the meeting is conducted remotely, the requirements of the KOMA are not suspended, so we will be conducting this meeting pursuant to the KOMA. On July 7th, 2022, we sent notice of the subcommittee meeting to all individuals who had requested notice of the board or advisory committee meetings. The notice was also posted on the board's website, ksbsrb.ks.gov. You may obtain a copy of the notice at that website. An agenda and other media materials have been posted on the board's website. You may also request a copy of the agenda by sending an email to david.fye@ks.gov with a subject line request for the agenda, and it will be sent to you. The notice contains information for the conference call and YouTube channel that allows the public to attend the meeting free of charge. The notice also states that if there are any technical issues during the meeting, you may call the board office at 785-296-3240 or send an email to bsrb@ks.gov. A recording of the meeting will be available on the BSRB YouTube channel following the conclusion of the meeting by using the link to the meeting on the agenda. So I will go ahead and open up the meeting. This is a subcommittee meeting for the Professional Counseling Advisory Committee of the Behavioral Sciences Regulatory Board. And the subcommittee has a limited jurisdiction. And I'll go ahead, and now that we've gone ahead and opened up the meeting and done roll call, I'll just provide a little bit of the summary of the charge to the subcommittee and how we got to this point. So in the spring of 2022, the BSRB began a year-long process by which each of the 7 advisory committees under the BSRB would be reviewing the unprofessional conduct regulations for the professions to determine whether new regulations should be added, other regulations removed, or language changed to clarify or modify existing regulations. Each advisory committee discussed this project and have taken different approaches to this task. At the Professional Counseling Advisory Committee on April 4th, 2022, the Professional Counseling Advisory Committee requested the creation of a subcommittee for this purpose. At the BSRB board meeting on May 9th, 2022, the board approved the creation of the subcommittee. And then at the Professional Counseling Advisory Committee meeting on June 6th, members of the advisory committee volunteered to serve on this subcommittee. So that is what brought us to the meeting today. In your packet of material for this meeting is also posted on the board's website. You should have 3 documents. The first is a copy of KAR 102-3-12A, Unprofessional Conduct. And that is a copy of the unprofessional conduct for the professional counseling profession. The second copy is another copy of KAR 102-3-12A. That is a copy of the unprofessional conduct regulations with some edits. A previous professional counseling advisory committee had reviewed the regulations a few years back and had marked up a copy of the regulation with some proposed changes. And so those are there for your review. Those could be forwarded along with any other changes that we talk about today. So we'll go ahead and talk about those today as well. And then the third document you have is a copy of the ACA, the American Counseling Association, the 2014 Code of Ethics. And so you have a copy of that as well. So this meeting kind of follows a little bit different of a format. There's not the normal things you would see in a full meeting, such as the executive director's report. But I think we can just go ahead and dive right into the subject matter. This meeting should last for about an hour. I can open it up to see how you would all like to handle this, but we can go ahead and look at the unprofessional conduct regulations. Some of the other advisory committees, when they have reviewed this, they have gone through the list and then taken it section by section to see if any of them should be changed. If you'd like to handle it differently, let me know. Otherwise, I can go ahead and share my screen and just pull those up and start that discussion. Okay. I don't hear any other thoughts on that, so I will go ahead and just share my screen here, and we can all take a look at the current unprofessional conduct regulations for the unprofessional or the professional counseling profession, and then we can start to go down this list. So like I said, this is KAR 102-3-12A, unprofessional conduct, and maybe we should start with just indicating the format. So the regulations follow a legislative format. So the first thing to follow is the small a, and then small letters. Within the small letters, the next items will be numbers, and then capital letters will follow the numbers. So if you see on this page, under B, the capital A is essentially B to A. And so that is all part of the same grouping. So, but do any of you have any thoughts on any proposed changes or modifications to KAR 102-3-12A, little a? That kind of just opens it up and says any license may be suspended, limited, conditioned, qualified, restricted, revoked. Not issued or not reviewed upon a finding of unprofessional conduct. Okay. Then under B, any of the following acts by a licensed professional counselor or licensed clinical professional counselor or an applicant for professional counselor license or clinical professional counselor license shall constitute unprofessional conduct. And how about if we go ahead and take 1 and 2 here together? Under 1, obtaining or attempting to obtain a license or registration for oneself by means of fraud, bribery, deceit, misrepresentation, or concealment of a material fact. And under number 2, it shall be unprofessional conduct, except when the information has been obtained in the context of confidentiality, failing to notify the board within a reasonable period of time that any of the following circumstances apply to any person regulated by the board or applying for a license or registration, including oneself. Having a professional license, certificate, permit, registration, certification, or professional membership granted by any jurisdiction, professional association, or professional organization that has been limited, conditioned, qualified, restricted, suspended, revoked, refused, voluntarily surrendered, or allowed to expire in lieu of or during investigatory or disciplinary proceedings. Have been subject to any other disciplinary action by any credentialing board, professional association, or professional organization. Have been demoted, terminated, suspended, reassigned, or asked to resign from employment, or has resigned from employment for some sort of misfeasance, malfeasance, or nonfeasance. Has been convicted of a crime, or has practiced the licensee's or registrant's profession in violation of the laws or regulations regulating the profession. Any changes to 1 or 2, A, B, C, D, or E?
Not from me.
No.
One thing that some of the other advisory committees have discussed, I believe, so under 2D, it says that you should notify the board if you have been convicted of a crime. And when we are looking at whether someone merits the public trust, we usually are looking at felony convictions or crimes against persons. So I think it should be maybe I just want to highlight that to see if it is still relevant, that it would be unprofessional conduct to make sure the board is aware of any conviction of a crime. Do you think that that's something that's appropriate to remain under the unprofessional conduct regulations?
So are they wanting to specify that misdemeanors are not things that the board needs to be made aware of? As long as it's not, the reason I'm asking is because sometimes people may have a crime against another person, but then they plead to a lesser charge. And so while it may not be a felony, I mean, so it could be a crime against a person, right? But depending on whatever deals people might get during the court proceeding, and I'm not a lawyer, is it possible that crimes could be pled down to something that wasn't what the actual initial charge was, and the BSRB, by changing that, might not be aware of certain acts that people committed if you specify felony or against a person, depending on what the person's actual charge ended up being.
Mm-hmm.
I don't know. Maybe it captures it all if you say person or felony, but I just don't know.
I think that's a good point. I had not thought about it from that perspective, but I think that would be helpful.
And if the answer is
If it's
no,
not a personal misdemeanor, do we have authority to do anything if it's not in the statute for that?
So Leslie, I think what you're referencing is that we have certain other statutes that relate to the licensure qualifications. And on some of those, it talks about what areas we would look at in terms of maybe limiting a license or the determination if someone should get a license. And those talk to things like the felonies and crimes against persons. And so you're saying if it's mentioned here, or should it be mentioned here if it's not included in those other statutes or regulations? Is that kind of what you're saying?
Yes.
Are those things mentioned here in the misconduct or unprofessional conduct, or are they another section, like another regulation or statute, I guess would be?
They're mentioned in another statute.
Because it seems like the statute, the regulation couldn't go further than the statute permits. So if the statute says one thing, then it seems like the regulation would have to fall in line with the statutory authority that's granted to the board in that area. So I imagine that's what you're saying, Leslie, too.
Asking.
Well, it would seem we couldn't have a regulation that exceeds the authority granted by the statute. So.
Yeah, and I think part of this may be that there are specific things that would be outlined that might prevent someone from getting a license, but then the board might be, it might be helpful for us to know about other convictions, whether we were able to enforce the other provisions of licensure upon those things. I think that's kind of part of the discussion. But it should also be mentioned that I believe some of the professions have different language in their unprofessional conduct regulations. I think some of them do mention reporting felonies, where other ones just say reporting conviction of a crime. So I think there is a little bit of language that's not consistent between the professions on that. But we can highlight that as something to maybe talk about in the future. But I'll go ahead and keep kind of working through some of these. Okay, so the list goes on, and I believe the rest of the list, essentially it says it's unprofessional conduct for these things to be done. So with number 3, knowingly allowing another person to use one's license or registration. 4, impersonating another person holding a license or registration issued by this or any other board. 5, having been convicted of a crime resulting from or relating to one's license. professional practice of professional counseling, or clinical professional counseling. So I guess that would also tie into the conviction of a crime, number 5. 6, furthering the licensure or registration application of another person who is known or reasonably believed to be unqualified with respect to character, education, or other relevant eligibility requirements. And then number 7, knowingly aiding or abetting any individual who is not credentialed by the board to represent that individual as a person who is credentialed by the board. So any thoughts on 3 through 7?
On 6, so that would be, excuse me, for instance, say could that be like a reference that completes one of those reference forms for licensure? It could even be like a professor, for instance. I put myself in the position, like if I knowingly had a student that I didn't think had the education to do this work, but went ahead and completed a reference anyway that said, I think they can go ahead and do this. Is that what this is referring to? Like that if I further a person's application through completing a reference that says they can do this when I don't think they actually can or shouldn't, that would be unprofessional conduct.
Yes, I believe so, because it does talk about furthering the licensure or registration application if the person reasonably believes them to be unqualified with respect to character, education, or other relevant eligibility requirements.
And that would also relate maybe to even whether it's a university person, but also the person who's supervising them in the field experience, practicum and internship.
Yeah, I had not seen, I've read through these, but that one just kind of stuck out to me as almost like there's a gatekeeping component built in. Because I know in the past, essentially, I believe the counsel for the board has said that the BSRB doesn't really have authority to not license folks once they've graduated a program, and because they're not licensed yet. So like investigating certain things prior to is kind of outside their scope, unless, I guess what they've said is that if the university doesn't think a person should be credentialed, we shouldn't let them graduate. And it seems like that's where this 6 comes in, almost as like our responsibility as either people supervising counselors that are in training or training them, teaching them to be responsible for doing that. So I think it's helpful for me to see, because I can point to that, especially when I'm talking to my students. Like I can't do this if I don't think that you have the character, education, other requirements. But I think that also gives teeth to the comment about the expectation for those of us in this work to not allow folks through the process that shouldn't be. And I think it supports the BSRB that by the time they get to you all, hopefully you should be able to trust these folks are ready. But I think it's important for counsel educators and supervisors to know that if they have questions about this, this is something we need to point back to, like, you have a responsibility here. I'm thinking training wise, I don't think folks ever see number 6 in there. So, anyways, I just want to make sure I understood that so I can communicate that to some folks too. Okay, thank you.
Good comments. Any other thoughts on 3 through 7? Okay, well, let's take the next chunk here. Let's look at number 8, failing to recognize, seek intervention, or otherwise appropriately respond when one's own personal problems, psychosocial distress, or mental health difficulties interfere with or negatively impact professional judgment, professional performance and functioning, or the ability to act in the client's best interest. Number 9, failing or refusing to cooperate in a timely manner with any request from the board for a response, information, or assistance with respect to the board's investigation of any report of an alleged violation filed against oneself or any other applicant or professional who is required to be licensed or registered by the board. Any person taking longer than 30 days to provide the requested response, information, or assistance shall have the burden of demonstrating that the person has acted in a timely manner. just because of the page break, do you have any thoughts on 8 or 9? Then let's move on to number 10. Number 10, offering to perform or performing professional counseling, assessments, consultations, or referrals clearly inconsistent or incommensurate with one's training, education, or experience, or with accepted professional standards. Number 11, treating any client, student, directee, or supervisee in a cruel manner. Number 12, discriminating against any client, student, directee, or supervisee on the basis of color, race, gender, religion, national origin, or disability. Number 13, failing to advise and explain to each client the respective rights, responsibilities, and duties involved in the professional counseling relationship. Or number 14, failing to provide each client with a description of what the client can expect in the way of services, consultation, reports, fees, billing, and therapeutic regimen or schedule, or failing to reasonably comply with the description. Any thoughts on 10 through 14 there?
On number 11, I don't disagree with it by any means, but I'm not sure what the definition of cruel would be. I'm not sure where that would be identified. I mean, I know cruel when I see it, but I'm not sure that in a document like this, I'm not sure how that's defined. Does that make sense?
Mm-hmm. Yeah, that has been one that we've had a number of questions about it over the years, because I think that is open to some interpretation.
I imagine I have some clients that think that some of the things we have to do in therapy are cruel because it doesn't feel nice to have to talk about things that are uncomfortable. But whether or not it's actually cruel is the different situation. So it's, I'd hate to see people being investigated for being cruel to clients who are just acting in the normal day-to-day operations of a therapeutic interaction, or a student who just doesn't happen to like my response to, something, goes and finds us and says, well, you treated me in a cruel manner because you didn't listen to what I had to say the way I wanted you to. So I do think that it'd be interesting to know how that is defined to better explain to both folks that are practicing as well as those that are trying to determine if they've been treated in a cruel manner, like what that actually would be.
Well, I'll go ahead and highlight that. One of the things that we could do in the future is we could look at some of the language that other states use or have for comparison. And so maybe there would be some states that might have a similar regulation that might define that term or use some different language that would be a little helpful on that. On number 12, discriminated against a client, and then it lists a number of items here. And so some of the other advisory committees have talked about this regulation and said that they would like to expand the list to match more of what some of the national associations are recognizing in terms of additional items to add under that one. So I wanted to highlight that for your discussion as well.
Yeah, the stuff that's missing from our list. And I know there's some conversation, Bob, you might remember when we talked about some of the changes. There are some things that didn't get changed previously because of some thoughts about what to add there. But the ACA code says age, culture, disability, ethnicity, race, religion, or spirituality, gender identity, sexual orientation, marital or partnership status, language preference, socioeconomic status, immigration status, or any basis prescribed by law. So it's a lot of, there are several things that are here in the ACA code that are not in ours. But again, I want to say there was somewhere along the lines when it came to either this or something similar, there was some rationale for why it was left as it was. And I don't know if it was given the nature of some of the political climate of things that were taking place at the time, some of the challenges that conflict that was there. I don't remember for sure, but on C5, the ACA code, that lists the non-discrimination components that if we were going to make it aligned with that, that's where we would find that content. Or consider, I guess, adding, that would be where the language, we would find the language there.
Okay. Okay. Any other thoughts on 13 or 14? Okay. Let's go ahead and move to number 15. Failing to provide each client with a description of the possible effects of the proposed treatment when the treatment is experimental or when there are clear known risks to the client. 16, failing to inform each client, student, directee, or supervisee of any financial interest that might accrue to the professional counselor or clinical professional counselor from a referral to any other service or from using any test, books, or apparatus. 17, failing to inform each client that the client is entitled to the same services from a public agency if the professional counselor or clinical professional counselor is employed by that agency and also offers services privately. And 18, failing to inform each client, student, directee, or supervisee of the limits of client confidentiality, the purposes for which the information is obtained, and the manner in which the information may be used. Any thoughts on 15 through 18 there?
On number 15, and I'm just asking the question here. So for instance, conversion therapy. The ACA says that it's unethical to provide conversion therapy to folks. Different states have bans on that type of therapy. Kansas does not as of yet. So under number 15, people talk about the possible risks of involved. There are clear and known risks to the client. At least that's what, generally would be stated. Would that mean that it's in Kansas that if somebody, as long as they let the client know about it, the possible risk people explain, that they could provide conversion therapy under 15, as long as they've made the client aware of it and the client agrees?
That's a good question. Don't know if there's any other provision that would relate to that specifically, or that could be interpreted in that way.
I'm wondering further down we'll find where people can't provide therapy that's not, but I'm just wondering, as I'm thinking through these, we might find the answer later, but just wanted to raise it here so we had it noted in case we don't find an answer.
Yeah.
That might be something for us to come back to.
Okay, I'll go ahead and make a note. Any other thoughts on 15 through 18? Okay, I'll move to the next few. Starting with number 19, revealing information, a confidence or a secret of any client, or failing to protect the confidences, secrets, or information contained in the client's records, except when at least one of these conditions is met. A, disclosure is required by or permitted by law. B, failure to disclose the information presents a clear and present danger to the health or safety of an individual or the public. Or C, the professional counselor or clinical professional counselor is a party to a civil, criminal, or disciplinary investigation or action arising from the practice of professional counseling or clinical professional counseling, in which case disclosure is limited to that action. And then I'll go ahead and I'll talk about 20 as well. Number 20, failing to obtain written informed consent from each client or the client's legal representative or representatives before performing any of these actions. A, electronically recording sessions with that client. B, permitting a third-party observation of their activities. Or C, releasing information concerning a client to a third person except as required or permitted by law. Any thoughts on 19 or 20?
Yeah, I'm trying to look at the, if I can find the ACA piece real quick to see. Here we go.
And I probably should have mentioned this at the very beginning, but one of the main reasons why we're going through these regulations is because the last time that these were amended was August 8th of 2008. So it has been a good 14 years since the last time, or close to 14 years anyway, since the last time these were changed. So a lot has changed over that time period in terms of technology. And so wanted to be thinking about some of this terminology through the filter of what it might have meant back in 2008 versus what it means today, and if it needs to change, especially as it relates to technology. So.
Yeah. So this isn't necessarily like the informed consent process as much as this is just getting consent to release information or to get it. So this is something separate from, okay.
Okay, I'll go ahead and move forward, but if you do have any thoughts or you want me to return to one of these that we've already talked about, just let me know and we can come back to it. Number 21, failing to protect confidences of, secrets of, or information concerning other persons when providing a client with access to that client's records. 22, failing to exercise due diligence in protecting the information regarding and the confidences and secrets of the client from disclosure by other persons in one's work or practice setting. 23, engaging in professional activities, including billing practices and advertising involving dishonesty, fraud, deceit, or misrepresentation. And I'll go ahead and stop at the end of 23. Any thoughts on 21 through 23? And one thing I'll mention here, I did speak with the investigators for the BSRB to ask if they thought any language should be highlighted and reviewed by different advisory committees or subcommittees. One item they talked about in number 23 is that the way that 23 reads, engaging in professional activities, including billing practices and advertising involving dishonesty, fraud, deceit, or misrepresentation. We wouldn't want someone to think that we're only talking about billing practices and advertising. So that language could be changed to say engaging in professional activities, including but not limited to billing practices and advertising.
Yeah, I'm wondering, like, when we're talking professional activities, yeah, I'm wondering how we further define that, because thinking about business practices, like online business practices that people have where they're not keeping their professional and personal content separated. You know, I'm looking at the use of even collections, for instance, you know, not informing clients that collections agencies are used in their billing or recovery practices. That's something specifically the ACA talks about, is that we're not supposed to use collections agencies without informing clients, and that beforehand that was going to be something they could expect. You know, and they also talk about, like, we don't participate in fee splitting. We don't give or receive commissions, rebates, or any other form of remuneration when referring clients for professional services. So there's different things that fall into that. That's A10B. There's fees and business practices under A10 in the ACA code. And so it might be that as we're thinking about how we're defining some of that, we could look there. But I do think that the including but not limited to would be good language. So that way it leaves it open. But it might help the board when they're considering what that means, or investigators, I guess they could look at that A10 for some of the stuff within that.
Okay. Thank you. I'll go ahead and highlight that. Any other thoughts on 21 through 23? Okay, we'll move to the next few. So starting at the bottom of that page, number 24, using alcohol or illegally using a controlled substance while performing the duties or services of a professional counselor or clinical professional counselor. 25, making sexual advances towards or engaging in physical intimacies or sexual activities with one's client, student, directee, or supervisee. Number 26, making sexual advances towards engaging in physical intimacies or sexual activities with or exercising undue influence over any person who within the last 24 months has been one's client. And then let's go ahead and do 27 too. Exercising undue influence over any client, student, directee, or supervisee, including promoting sales or of services or goods in a manner that will exploit the client, student, directee, or supervisee for the financial gain, personal gratification, or advantage of oneself or a third party.
I feel like I'm talking a lot. I hope that that's okay. It's my first meeting of the day, so I've got a lot to say. This is an area, if you look at the proposed adjustments to this, is where a lot of the work was done. So you'll notice under 24, the using alcohol or illegally using a controlled substance is removed, and it's being under the influence of any substance that impairs professional judgment, which I think is helpful. At the same time, it's like a person, you know, if a person takes a medicine their doctors prescribed to them that's known to impair judgment, but it affects different people in different ways. I don't know how far that goes. I know what this is getting at, which is you shouldn't be in a place where you can't perform your job responsibilities. So the new language, I think, may be more comprehensive, but I just want to make sure that it doesn't, since it doesn't say illegally using, I want to make sure that it doesn't, it's not so comprehensive that people using medications in a legal way, even though that medication could be known to cause impairment, I want to make sure they wouldn't find themselves in trouble under that proposed language. Otherwise, I think the new language is more comprehensive and probably fits better.
And like you stated, that there was a version of this document that had been marked up with potential changes. So I went ahead and stopped sharing my screen with the original language. This is the second document, the one that had the proposed changes. And so the item that you were talking about, I think it was number 24. So the current language on that one does say using alcohol or illegally using a controlled substance while performing the duties or services of a professional counselor or clinical professional counselor. So the part of that language in the proposed change would be struck, and then new language would be added so that it would say being under the influence of any substance that impairs professional judgment while performing the duties or services of a professional counselor or clinical professional counselor. And you mentioned that there could be a component that whether it should be something that's a illegal substance or whether it would be something that would be something that's provided therapeutically or something legally. So in terms of this proposed change, do you have thoughts if this is something that should move forward or something that we should adjust further?
I think it's worth it to consider a change in the language. I think it would be important to know if the proposed language was adopted, how would this be interpreted? And in what circumstances would we be considering this, since we're taking out the language illegally? Because it doesn't have to be a controlled substance. I mean, that means a drug that's classified by the DEA or the government I mean, so there could be, normally that's referring to our Schedule 1, Schedule 2, mainly Schedule 2 drugs, but like Vyvanse is a controlled substance for ADHD, Focalin, so these are controlled substances that are not illegal. And I mean, could they affect somebody's professional judgment? But maybe it doesn't for that person. So I just want to be clear how this could be interpreted and what circumstances to make sure we're not opening up a situation where I know what this is meant to be looking at, but I also just want to make sure I know how the language would be interpreted with the change.
Isn't the changed one, I like it better because it does say any substance. It doesn't, because people can be impaired by legal substances. So right. I like the proposed language. I think it's good because we legally use all different kinds of substances that, if not used appropriately, could impair our professionalism.
Right. Like all the different THC substitutes, Delta 8, Delta 10, all the different,
Absolutely.
They're legal, but not necessarily good for a counselor to be doing right before they have a session.
Exactly.
Yeah, I like the way that it's worded currently. The way that it's proposed to be worded. I like that.
How about for number 25? I have on here the proposed change to 25. The current language says making sexual advances towards or engaging in physical intimacies or sexual activities with one's client, student, directee, or supervisee. And the proposed new language would say engaging in sexual behavior, including sexual harassment, making sexual advances towards or engaging in physical intimacies or engaging in sexual activities with one's client or one's active client, active student, directee, or supervisee, or anyone with whom they have power or authority.
This is an area that I think we need to be mindful of, especially as it relates to students. I guess my question is, when does somebody stop being a student? Because I think that there needs to be certain protections in place for students and recourse that they can take against faculty members, I think especially in supervisors that engage in, I guess what I say, we need to have very few loopholes for those that are in power to find ways to circumvent the system to be able to have relationships with these folks and not end up in trouble for it. Because I'm familiar with situations where that's happened. And it's, I think we need to ensure that our professional misconduct statutes, our regulations protect those folks as much as we can. Clients as well and so forth. There's a lot of stuff in there for that, for the ACA code, but I guess when we say active, is that determined by being actively enrolled? Is that kind of what we're talking about? Or, because I don't think active was in there previously. So is there a difference between client and active client? Active would suggest right now, but
like in present tense.
Mm-hmm.
Yeah, this new language, the new language would be any words that are underlined.
Mm-hmm.
So use of the word active is something that would be added to the regulation.
Mm-hmm. And would the BSRB refer to active student being the fact that they are enrolled in the program? And so if that student was unenrolled and a day later the professor and the student had a sexual relationship, that the BSRB couldn't do anything about that? Under either section, whether it was active or the current language, which just says student or supervisee.
And I think these proposed changes occurred prior to my time with the agency. So I'm curious when these were originally discussed. Leslie Allen, do you recall if there was any conversation about adding a new definition for the word active as far as active client or active student?
I wasn't at that meeting, and they had students work on it.
Okay.
And brought the changes. So I wasn't at the meeting where they reviewed the changes.
Okay. So I guess that is something I'll go ahead and highlight, because we definitely would need to know a clear definition of what active means in this context, so that people would be able to interpret it. In terms of other language in this regulation, I did want to clarify that there has been some conversation with other advisory committees about what the term supervisee means, and if that is purely related to, like someone receiving clinical supervision, or would it also refer to a supervisor-supervisee relationship in terms of employment supervisor? And our legal counsel has weighed in that unless it specifically says employment supervision, we should interpret it as not meaning a type of employment supervision, that it should really mean the relationship in terms of providing, like clinical or other level supervision between individuals in the profession. Another item that some of the other advisory committees had discussed is under number 26, the current language of the regulation talks about it being unprofessional conduct to make sexual advances towards or engage in physical intimacies or sexual activities with, or exercising undue influence with any person who within the past 24 months has been one's client. And so there has been a lot of discussion with other advisory committees about is that an appropriate, maybe not appropriate is the wrong word, but is that the standard in terms of the length of time? There was a suggested change in this language that would make that 60 months instead of 24. And it also included some language that would say engaging in sexual behavior, including sexual harassment, making sexual advances towards, engaging in physical intimacies or sexual activities with, or exercising undue influence over any person who within the past 60 months has been one's client, client's romantic partners, or the client's family member, or anyone with whom they have power or authority. So I thought I'd call your attention to number 26 and also the language of a potential change to item number 26.
I do remember, I was just going to point this out to Andrew, I believe, had made a comment about 60 months not being long enough.
I do think you're correct. 60 months, 5 years is the new ACA standard, but social work doesn't permit it ever. And I don't see why we should ever find a situation where that would be something we would permit. I mean, maybe the people at ACA and the revises have some explanation for why we would say after 5 years that could be okay. But I've always been of the perspective that if they've been your client or patient or something along those lines, that at that point, I don't think you have any business having a relationship with a person you were treating. But I might just be thinking too narrowly about that. I don't know. But
I believe MFT is doing just if they've been a client, isn't it, Dave?
I don't recall. Each of the
There's so
different
many, I know.
well, each of the different advisory committees is having separate discussions, and so we've been taking notes as they go through those. And the plan is to bring all these back before the board at the end of the year. But they're not all straight in my head at the moment between the different changes they're all considering. So.
And the new ACA language does include clients, romantic partners, family members, and so forth. So that language that's added there was from the ACA code as well.
Which one is that in, Andrew?
It is A5C, sexual and or romantic relationships with former clients.
Okay.
I don't know if we have ever added this or not, but A5B also refers to the fact that counselors can't engage in counseling relationships with people that they have ever had a previous sexual and or romantic relationship with. I mean, because dual relationships aren't prohibited. So like you could have had a prior relationship with somebody in some fashion and potentially still work with them. But if you have ever had a sexual or romantic relationship with a person, you are prohibited under the ACA ethics from ever treating that person as a client. So I don't know if we need to consider possibly adding that into that. But yeah, 60 months, I think minimum it should be 60 because that's the new standard. I would be okay with saying if they've ever been a client, you don't, that have to get other people's thoughts on that.
What about other members of this subcommittee? Do you guys have any thoughts on this regulation or the proposed changes to the regulation?
I agree with Andrew because I feel like, social workers have gotten quite a lot more respect because of their, about this subject, I think. I think that we need to all be held to the same standard if we're in the helping profession like this.
I agree.
Yeah, I don't have a problem with either 60 or ever. It would be fine.
Fine.
I think if you look at the reasons for violations, sexual relationships with clients is, I think, usually the number one reason. Like when you look at the major stuff for most professionals, it's having sexual relationships with a client or romantic relationship. And so I think that if people already are having trouble with that, anybody's willing to wait 5 years, I guess. But I just think setting a standard that says we just don't, when we see the problem that it is across the helping professions, which I think is sad and unfortunate, we just have to set a standard that says you just don't do it. So whether they're active or later on, so I have clients that come back to see me years later, right? It's like, for me, they don't ever, if they were a patient, they're always a patient. They're never going to be my friend. I'm not going to have a relationship with them. So it's like, I was always the treating provider, no matter how far we are from that episode. That's who they were, and that's who we are. So.
Well, this is really good discussion. We're getting close to the end of our time today. I think if we look at number 27 here, there's no proposed change that was added to this text previously. Do you guys have any thoughts on any changes to number 27? That's the regulation that involves undue influence. Okay, well, if not, go ahead and stop sharing my screen here. In total, there are currently about 56 unprofessional conduct regulations. And so we're about halfway through. So I think we're making good progress. I've highlighted the items that we've talked about today. So I think probably the next step would be to go ahead. The next advisory committee meeting for professional counseling is the first Monday in August. So we can just report back and discuss some of the changes that were highlighted here. And so I'll go ahead and bring those minutes and make sure that they're available at the next advisory committee meeting. And we'll just include it on the agenda for the next meeting, and we can kind of talk about the progress so far. And then we can look to meet again maybe in September, just for another hour, and then complete the second set. And then if you have any language about any items that were not covered in here that we should add that are brand new, or if you see any that you believe maybe have outdated language and we could remove, go ahead and keep that in mind too. But I thought we made really good progress today, and I appreciate all of your conversation and thoughts and comments. And do you guys have any questions before we go ahead and end the meeting today? Well, thank you all for your time, and I look forward to seeing you all next at the advisory committee meeting in August.
Thank you.
Thank you all.
Bye, everybody.
Bye.
Bye.